and I'm not here to give legal advice. Now, therefore, that leads to a question. How can this non-lawyer be talking about trial strategy? Let me give you a little background on my experience with this stuff. For about the last 25 years, I've been dealing pretty exclusively with parental alienation cases in the capacity of evaluator, expert witness, that sort of thing. In 2006, the last 17 years, I've been doing exclusively consultative work, meaning that I've been, therefore, witness to hundreds of alienation cases. I've seen dramatic failures and some incredible successes and so forth. So, one more little thing about my background. Before I got involved in this psychological kind of stuff, my first interest was anthropology. And anthropology has a concept called participant observation. So an anthropologist will go to an exotic culture and sort of go native, if you will, and basically describe what happens in this exotic culture. Well, the exotic culture I want to describe to you today is what I've seen in the last 20-some years, is the exotic culture of family law. Because it's got some rules that nobody explains. It operates by its own internal logic that seems to have no direction at all. But what I want to do is try to decode that for you a little bit to see if we can make some sense of it. And what I've noticed, some things that we see over and over again. Why did we do that?
Oh, brilliant slide.
What did I do?
Be quiet, be a polite participant observer.
Oh. This is an exotic culture.
It is.
Oh, I did that one. That's very good. Okay. In this school, my wife did this. So that's what I'm here today to try to talk about. And again, like Demos says, please interrupt and let's have an interaction about this stuff, because there is no absolute, we need to have a discussion about this. One of the first thing I've learned, and if you walk away with one thing that you get from my contribution to this, for the court to get one of these cases right, there's always one thing that happens. If this one thing does not happen, the court will predictably get it wrong 100% of the time. And that is, the alienating parent must be exposed. By that I mean expose their behavior, their character, and their attempt to defraud the court, because that's what's happening. And they're very, very good at it, as we know. So that's what we're kind of up against, is being able to expose these people that are so good at what they do. So this is the axiom 1. I don't really have an axiom 2, but I didn't want to just call it axiom, so also it's axiom 1. The first problem we have is the court's bias. I mean, the court, we were talking earlier, just a moment ago, the court is biased toward protecting children, which of course it should be. But as we know, that is the particular bias that becomes exploited by alienating parents, by making false abuse allegations, et cetera, causing the court to fall back on its heels, slow everything down, and the alienation then furthers and furthers. So part of what we have to deal with is that part of the bias that the court has too is that the incredible discretion that family law judges have in the United States and apparently in the UK as well. In my attempt to understand how this works, my understanding, and I'm told by attorneys, that the rules of evidence are really supposed to govern this thing. And the Supreme Court has blindfolds at the Supreme Court down the street there. The rules of evidence are supposed to eliminate bias, et cetera, et cetera. However, in the case of family law, the rules of evidence really are more like guidelines, because they have to balance that against the best interest of the child, which allows them to bend the rules, break the rules, and even and completely ignore the rules. I mean, we've all probably seen judges rule on things that are completely inconsistent with the evidence, because they just sort of had a feeling, and they can do that. And the ability to reverse that is very, very low. And there's lots of appellate attempts, but very few reversals. I mean, I'm describing things I think we're all quite familiar with. So far, does this sort of fit everybody's understanding, experience, etc.?
Yes.
Okay. Part of the problem with this too is the training. Judges, let me back up. Because of the rules of evidence, as the judge looks down from the bench and sees two litigants, two tables, typically with two attorneys, it appears the default setting is that both these parents are equally culpable. I mean, I've heard judges say, I remember there was in Southwest Florida, a judge said, these are just like two scorpions in a jar stinging each other. I mean, that's how it's perceived, is that both are equally culpable. We know in alienation cases, that is not what's going on at all. So that's our first task, is to be able to expose that, okay? So, as a consequence of that, and in addition to that, judges also are trained, in addition to that default setting of perception, when they see these two litigants down there, they're telling very different stories. They're just looking back and forth going, what's really going on here? In addition, judges in judicial colleges are typically trained that both parties are culpable. And that probably comes from family systems, and typically that would be the case, except in these cases it's not. It's a setup. Yeah, Howard?
Do you have a reference for that, like custody evaluators default to thinking most people have culpability? Is there like a book that they read in their freshman year that says that? Or?
I don't know of one. Randy, you're always the research guy. Between you two. Yeah.
California, Janet Johnson, she taught that, and those who were custody evaluators, like from Los Angeles and stuff.
Yes.
I think I'm right about this, but if I'm not, but trained to in this idea that both parties are wrong.
Yeah.
Or
Okay.
that both parties contribute.
I mean, that seems to be part of the 2001 reformulationist thing that we saw. That was really a committee that published a whole journal that had nothing but those articles. The one that Steve brought up yesterday. So yeah, I mean, I think it's explicitly noted there. I wasn't aware quite as explicitly, but I think it's just a general.
The prevailing notion is part of the high conflict background.
Yeah.
That's propagated.
Yes. Okay. So I think that's what we're up against. You're in a court case with one of these, and that's the bias that you're basically dealing with. So how's the best way to deal with that? Yeah, Randy.
Wait a minute.
So before the reformulation, going back 20 years, county courts were establishing county court rules for people who were conducting evaluations and have X number of CEUs about those testimony. So in that literature is what was taught, and it still goes on today, which is in high conflict divorce cases, both parents are responsible for the conflict. That template doesn't fit over. And what that teaching error does is it sets up a confirmatory bias.
Yes. Exactly. Thank you. That's a very good point. Yes, Jim.
We have pretty close relationship with the two Kane family court judges in our area, and they're much more comfortable talking about high conflict than they are about parental alienation, and it would be nothing that would make them happier than if they could treat a parental alienation case as a high conflict case, because I don't know, it just fits their mindset that they don't like parental alienation. It's just a troublesome concept for them. So if you think about high conflict, and if you have high conflict, you have to have two people to be in
Yeah,
conflict.
and I think that we see the confirmatory bias because a judge is asked to do something very difficult if they see what's going on. They have to make an order that's over the protest of the child, typically, and in the face of all kinds of allegations that the judge has to be comfortable with are not true. So that's a high That's a high mark, as in the context of this sort of bias. There's a hand up over here, yes.
Wait a minute. You talk, they listen. They talk, you listen. Keep talking.
Well, she wanted to talk.
All right.
Make your point. Yes, I did. Thank you. Thank you.
I would agree. I just wanted to add a subculture to our culture
Yeah.
that I was recently exposed to in Minnesota, a current case, and it is not in family court, it is in juvenile, and it's a CHIPS case, and it is on the table for termination of the mother's parental rights. It's in child protection services. And in Minnesota, what I learned from last month is that we have an issue in Minnesota where the juvenile system quickly moves to terminate parental rights, and you have to consider in community.
Wow.
And this is a mother that they're looking at removing her parental rights, and she is the alienated parent. So it's a challenge. So I just want to add that subculture to this culture, so if anyone has any experience or anything, I'm working with the mother's attorney right now to see if we can come up with a strategy. And there's parental alienation as well. Yes. So their reunification, office reunification therapist just resigned, and it was not successful, of course.
Yes.
Michael, is anyone familiar with an article by Michael Friedman that was in the American Journal of Family Therapy in 2004? The so-called high conflict couple, a closer look. It's an excellent article that describes this bias
Yes.
towards both parties are equally responsible.
Say the reference again.
Okay.
They felt slowly.
Michael Friedman.
Microphone further away.
Sorry. The American Journal of Family Therapy, 2004, the so-called high conflict couple, a closer look, Michael Friedman. This article examines the concept of the high conflict post-divorce couple. It is suggested that the use of this concept encourages the belief that post-divorce conflict is more or less equally the responsibility of both parents, whereas such conflict is often driven by one parent. The understanding of unilaterally driven post-divorce conflict has important implications for constructive intervention and for public policy.
Yeah, very good. Thank you. Thank you. Let me go on. Basically, we want to spend a few minutes talking about what we all know: the bias towards equal culpability, the training of the culture, all of that goes along with it. So what do we do about it? How's the best way to address it? What I see very often in incompetent evaluations where alienation is under the nose of the evaluator but it's not ever identified is a failure to create an understanding of a timeline, progression of things. That's absolutely critical in one of these cases to be able to show what's happened over time. And that very often in all the, if you can think about all the incompetent evaluations you've ever come across, you'll notice that they don't really pay much attention to that. They operate under a bias that whatever goes on now must have been whatever goes on back then. So as a consequence, one of the things strategically that is important to do in whatever way possible is to really emphasize the pre-separation relationship between the child and the parents, more so than an evaluator even wants to hear about. So when I'm advising clients who are about to sit for an evaluation or to meet for the guardian ad litem or testify before the judge, I always advise them to spend more time on the pre-separation relationship between themselves and each child than the audience really even wants to hear about. And I don't mean in general terms, I mean specific examples. Because what we have to do is give the audience, be it the evaluator, the guardian, or the judge, we have to access their emotional reaction. We have to get them to be able to get a picture in their head of what happened. And they remember they saw this incident with this this guy who's been accused, let's say, of being an out-of-control lunatic. But yet in this one example, he shows patience and a balanced reaction and so forth. But it has to be a specific example to get into the head of the audience, be it the judge, the guardian, the evaluator, whatever. So that's very important, I think, to advise clients to really spend time with that in whatever opportunity they have. I've had people bring in artifacts of their pre-separation relationship and put it on, have it just lay on the table and the litigation so the judge can see all this stuff. There'll be trophies, there'll be this, that. It may never even get pointed to, but it's in some way referenced so that the court gets an emotional sense of what's happened in that child and that parent before the separation. That is critical. If that doesn't happen, you get it wrong every time, every single time. So that's absolutely important to create a timeline and have that be a theme that is repeated over and over and over again in very, very concrete terms, so that axiom 1. This all goes to exposing the alienating parent. Just 1 minute, let me finish my point. By showing the pre-separation relation, if that flies in the face of the story the alienating parent is trying to sell. So that's the first step in taking the mask off and exposing their attempt to defraud the court. Yes, Demons.
Mike and I wrote a chapter about this. One of the things that we try to emphasize, we emphasize this in a 2013 handbook as well, is get a three-part table. Three-part table. The first column is the date. The middle part is what happened. Why did it happen? Who was involved? Why do we give a crap? How does it impact on where we're going? What does it show? The third column is, and this goes directly to Dr. Ball's point, how will we prove it? Because if you can't prove it, it's worth nothing. If it's he said, she said, you don't go anywhere. You need to document. Queen's Counsel understands this. You need a transcript. You need a police report. You need a eyewitness with credibility. You need a former court record. If you can't prove it, it doesn't matter.
Thank you. And I'm going to get into that in a later slide. These slides, by the way, I think of these as little modules. They sort of exist on their own. Like this first one is about the court's bias, and the next one, I'm not sure what it is. Let's see. Rebranding the targeted parent. This is one of the things, and we're sort of jumping around, but I think that's certainly possible to do. So in the midst of trying to expose the other parent for what they've been up to, we have to rebrand the targeted parent. And what I do is sit down with them and think, okay, give me a list of all the things you've been described falsely of being. And typically, if it's men, it's violent, and it's out of control, and it's controlling, and all those things. And if it's women, it might be those things, but it's more likely to be kind of crazy and out of control in that particular way. So I asked them to make a list of that and to be very, very sensitive to any reaction they may have with any of the various audiences involved in here. This may be the judge, the guardian, the evaluator, whatever. To be sensitive to any reaction they may have that may mimic any of those negative qualities. Because again, like Randy pointed out, confirmatory bias is very powerful. And if I've been described as being this out of control, angry guy, and I'm sitting with an evaluator, and I'm reasonably frustrated because I don't see my kid anymore, and I get angry, I've just confirmed it, haven't I? And so that's what happens. There's that feedback loop. So you have to get the client to really buy in on this. I mean, you have to get them to really settle in, and most, in my experience, most targeted parents are the opposite of how they've been described. So this is not a terribly difficult thing. They really are balanced, and it's a projective problem that's happening with the alienating parent onto the targeted parent. So I think that's I sort of addressed that already. As far as the rebrand, any thoughts on that from anybody? Yes.
I'm kind of curious whether it works or not, because, can you say, in this case, the person bought into it, Mrs. Jones, Mrs. Smith, I worked with her on this rebranding. She did this. She went to parenting classes. She presented an absolutely neutral or positive or soft-spoken affect, and she won. And Mrs. Tynes, she didn't do that, and she lost. Can you actually, is this evidence-based?
Anecdotally only. I can't give you numbers on that. But I can tell you, this is less important, frankly, than the first point, axiom 1, the only axiom there is, of exposing the alienating parent. That is the premier thing. If that is accomplished, this becomes less important, I can tell you that. One of the cases that I can give you a specific example had to do with I've talked about this before, you probably have all heard about this, the Dwayne Wade, the basketball player. He has two little boys that went through a divorce, and I can talk about that, I was given permission to do so. Two little boys, 4 and 7, going through a divorce about 3.5 years ago. His attorney in Chicago, a fellow by the name of Jim Critican, contacted me, and I thought, oh, we'll talk to this guy on the phone a couple of hours, and then we'll develop some sort of strategy. But he sent me a box load of documents to read. A lot of psychological work had already been done. And this is a high-profile, high-budget case, so there have been a lot of people involved, as you might imagine. But he'd been accused of everything, abuse, neglect, everything that we're all very, very familiar with. So, and also, the court had appointed a psychiatrist to do an evaluation. The psychiatrist did the evaluation and basically said, well, she's a little bit crazy, but he's very busy. He doesn't seem like he's a bad guy, but these little boys need to stay with her in Chicago. He was living in Miami at the time, so it would have been a relocation issue as well. It was litigated in Illinois. Hang on one second. So we had to overcome the recommendation of the court-appointed psychiatrist about this. No easy task, and the guardian, by the way, had fallen in line with that evaluator as well. So what we did was Critican came down, flew down actually, and we spent the better part of the day devising a strategy. And through development of questions that he could ask the alienating parent, he had her on the stand for 8 days. I realize that's unusual. But as a consequence of that, there was no place for her to hide. I mean, it was very clear who was reasonable and who was not reasonable. But being able to ask her questions in certain ways that just caused her to just sort of respond and over-respond and expose herself, we were able to do that. I mean, one of the things we see with a lot of the alienating parents, now I'm jumping ahead, personality disorders. And now in the case, and a lot of them have really narcissistic qualities. So if you push on that button of adoration, which every narcissist lives for, and you begin to challenge that, then you're going to get reactions. The mask is going to start to come off. So I think you have to be sensitive to that and be able to articulate questions in a way that will do that. So, and I'm getting way ahead. Parenting classes, and this is all part of the rebranding, etc. So part of that, again, is to, you don't see this slide a lot because axiom 1 is very important, because part of the rebranding is flying in the face of all the false allegations, isn't it? So that's just, you can see how that's important, but that's probably not the most important. The most important part is the exposure part, okay? I've heard a lot of lawyers, I've had to try to talk a lot of lawyers, and you're really going after the alienating parent. Most often you'll hear things like, well, I don't know, I think that makes our client look bad. I think if we just put on our case, we'll be fine. Well, you won't be fine. You'll lose every time. You have to go after the alienating parent. You have to do it, I think you have to do it respectfully and reasonably, but you have to do it. And then you have to do it some more and some more. Yes?
Well, there are different, I know, Mike, that you train lawyers to use different strategies in their examination. Some of that can be go right at them. Others can do the Detective Columbo from the old TV show, like, well, I just don't. Yeah. But what Mike is teaching here is that you're exposing lies. I train lawyers to make lie lists. In other words, what's the lie? Get a transcript, get a witness, get a statement, get a tape, get a photo, get a video, and how do you prove it's a lie? Because we can't prove it's a lie. You better not even bring it up. Prove it's a lie. Prove it's a lie. Prove it's a lie. Prove it's a lie. And in one case, I was talking to Mike about this. We wrote them on the board, and every time we proved it was a lie, we went over and
Right. It's those things like that that really, again, this is where I'm getting ahead of it, we'll see in a moment. It's about persuasion. Well, I'm going to talk about persuasion and proof in just a moment, but yeah, we get a question over here.
Just a quick question.
Yes.
What happens if, you're in the courtroom and your attorney is trying to present evidence and the judge simply won't allow it? And he, it's been an instance where the judge gives the evidence, here is the exhibit B, attached to the case marked thereof, period, and the judge does that.
Well, again, the judges have absolute control of the captain of the ship, and I think very often the remedy for that might lie in contexting whatever the evidence is. In other words, being able to bring the court gradually to develop an understanding about it or a curiosity about it. I think the preparation of it is very, very important. We'll talk about that in persuasion. Well, yeah, and to do it gradually. Yes, Steve.
I just want to add something. It's very foreseeable what those objections will be. So one of the things I know Michael does and I do is I say to the attorney, I want you to ask some questions of the mother or father who take it. But you have to anticipate there's going to be an objection that you're being argumentative. There's going to be objection of relevance. There's going to be other objections. And the attorney has to be ready to say, no, Your Honor, it's not argumentative. I have, this was a custody case. I have a right to explore Mrs. Smith's insight, judgment, understanding of the child's psychological needs, and so on. That's not argumentative. That's the crux of my case. So if you prepare the attorney to do that, then it usually withstands the objection. If you don't, many of them just blink like a deer in the headlight and skip the whole line of questions. I can steal 20 more seconds. Recently, someone called me and said, we never got to do questions 5 to 12, 30 to 40, and whatever, 60, 70. I said, why not? Well, the judge excluded them. Well, how would the judge know what they are? How could he exclude them? Each one by one? No. When the judge excluded the first one in the group, my lawyer just moved on. So that's what you have to anticipate.
Yes. Robert, good. Patiently for a while.
We know the standard of proof is preponderance, and I was wondering how that can work for or against your client.
I'll get to that. Hang on. Yeah. I'm not sure if that's the next one. Oh, yeah, it is. Okay.
Oh, awesome.
Persuasion versus proof. The court operates, lawyers are trained, please confirm or disconfirm this, that it has to do with proof. You said that earlier, Dino, so how do you prove it? And that's a legal term that has a certain implication. In reality, however, here's the anthropologist saying, how does it really work? It's really not about proof as much as it is persuasion. Because really the court works by a preponderance of the evidence, things like that. It's a probability statement. That's how the court really truly operates. So I think if an attorney understands it's about persuasion, they'll go at it a little bit differently. And they will attempt to, it's really about getting the judge's interest, curiosity, getting the judge's anxiety up if they don't do the right thing because they're going to read about themselves in the paper. Whatever it takes like that to get the court's attention persuasively. If you think about it, alienating parents are very persuasive, aren't they? They know this stuff. I mean, they breathe this stuff. This is the stuff that they do automatically on their own. They've been doing it their whole lives. They've been trained to do it. So we have to take a page out of their book, so to speak. The advantage is, however, we don't have to make up reality. You simply have to present it, but do so in a persuasive way. That leads me to recently, one of the questions that comes up quite a lot is, do you use the term parental alienation? I mean, when you're talking about that. I mean, that's a lightning rod term sometimes. And if I was doing this talk 10 years ago, I would say absolutely. However, I've learned that may not be the best idea. I now believe it's more persuasive. And really this comes back to probably some old sales technique that car salesmen are taught, and insurance salesmen are probably certainly taught, where you basically describe behavioral things that are going on. You keep in mind the statutory language in all 50 states about divorce and about parental behavior. It's about behavior. Can't do this, can't do that. So if you start talking to a judge or presenting evidence in terms of behavior and not labeling it, and basically take them, I believe in all states, one of the factors that courts look at is which parent will encourage a relationship between the child and the other parent. Okay? So alienation is the opposite of that. It's a sabotaging, as we all know. So if you can describe events, get direct testimony of this happened, that happened, that show basically that there is a sabotaging, an attack of that relationship, it's the opposite of what the judge is tuned in to see. They're going to begin to react to that. And I always say, what you want to do is take them up to the edge of that with all the several specific examples. The goal is to get them to think, parental alienation cases. Because we know from psychotherapy, if something is experienced as an insight, it seems more real, doesn't it? And so that's what we want the judge to do, is have an insight that might.
alienation syndrome. Well, she said, I never said anything about parent alienation. It
Right.
doesn't matter.
Right.
They throw it out. They set the groundwork. The next piece is if you just focus on behavior, you never said the word alienation. So now we want to refer somebody from Linda Gottlieb to reunify a parent because they've been alienated. We never even talked about
Well,
alienation.
thank you. Let me clarify what I mean. I think part of it's preparation. If I want to sell you a car, I'm going to start talking about, find out what your car needs are, find out what you like, and start talking about this car, that car. It's about preparing the way. So preparing the way, I think eventually you do say that, you say the magic words. But I think the goal is to get the court to go, ugh, because then you've sold the car, basically, by that particular point. So yeah, I left that part off. Thank you for, that is important.
You don't want to sell them a motorcycle if they're coming in for a car.
Right, exactly. And if they see you coming with a brochure, then the door's closed, as we learned on the first day from Where Is She, Judith, I think. Yes. One example that I think is a good example of persuasiveness that really isn't proof, but it's effective, and that is hypothetical testimony. One of the things Dr. Evans and I do, sort of as a tag team in certain cases, is Bob will come in and not perhaps review anything. Will come in and simply be there as an expert to educate the court on the phenomenon of parental alienation, once that term has been registered. So if it's, the hypothetical questions are, Dr. Evans, if I told you this, and what might that mean? Well, if it's parental alienation, it would mean, and you set it up that particular way. The last time I did one of these things was in Poughkeepsie, New York, quite a few years ago. And it was interesting. I went in there, and there were two attorneys, and they sort of attacked me, saying, you didn't examine anyway. I said, no, I really didn't. I'm here to explain how this phenomenon works. And then there were hypothetical questions. Then the final part of it was, and it's up to the court to decide if it fits. And I think that part is important because it doesn't shove it down the throat of the judge. That is critically important. So that, in that particular instance, at the end of the hearing, or toward the end of the hearing, the judge asked opposing counsel if it was okay if I went back into his chambers and he said he could ask me questions about a different case. So it didn't prove anything, did it? But it certainly was persuasive. So I think we have to drop breadcrumbs. We have to create things gradually that happen. Yes?
Yeah, just going back to the previous subject, I think it's important to point this out, is that interestingly and curiously, my ex-husband sued me for alienation of affection. So how is it that the court allows him to sue me for alienation of affection, and they don't see the parental alienation? Don't you think that's a little odd?
Well, there's a lot of things in family.
Hold on a second.
Yeah, okay.
Hold on a second. Hold on a second.
Who said hold on?
I did. I'm the moderator.
I can't say.
Papa Bear said that.
Hold on. Wait.
Is that God talking to me?
Yeah, it is. And she's pissed off. Look, just hold on a second. You've got Kathleen Rock and you've got Kelly Boyage coming up. They're on deck. They're coming up this afternoon, and they're going to give the secret knowledge about how to win these cases in the first 5 minutes immediately after the coffee break this afternoon. So don't ask Dr. Bone about why the judge does this and that. He can only tell you as a consultant, but you got Kelly, and you got Kathleen coming up, so hold it.
Thank you.
No pressure.
In terms of evidence, here's what I've found. Again, this is the anthropologist watching what works. I mean, how many times have we heard, if I heard from a lawyer, oh, that can't happen because of this rule, and guess what? It happens. So beware of those, well, this can't happen. The system I use is arranging evidence in two tiers, tier 1 and tier 2. Tier 1 is the indisputable stuff, the stuff Demos was talking about, the lie list. There was a case that I believe we both might have been involved in where there was a father who was accused of being an alienator. He was accused of, at a award ceremony, emotionally attacking his 11-year-old daughter, you know, upsetting her, et cetera, to which the mother then, which didn't happen, but the mother called the police because there was an emotional exchange. He was being supportive of her, and he hadn't seen her in a while, and she reacted very positively. He was holding her, you know. Anyway, the cop shows up and basically makes a report that's doesn't have any descriptive kinds of things in it, but I believe he was deposed, and later came back to testify that nothing of what the mother said was true at all. So that became, that evidence, that made the lie list. That would be tier 1. And in my experience, if you get about a half dozen good tier 1 things going, and they're rock solid, you've turned the attention of the court at that point. Then tier 2 is more he said, she said, and that stuff flies by. If you don't have tier 1, it won't. That's what you were saying earlier, Demos. If you don't have anything, but you have to create the foundation of the lack of credibility. Again, the attempt to defraud the court, to get the court to think otherwise than the truth. So I think this system of creating a rock-solid foundation that attacks the credibility that's not disputable, that's very, very important. And that's not always easy to find, but it's worth looking for. Because again, that's the goal, is to expose. Yes?
Sort of a very specific question. Do you think it's worthwhile for a lawyer to use words like, this person, you know, my client's ex-spouse or almost ex-spouse is trying to defraud the court by doing this? Do we use those words, is trying to defraud the court? Because that's not respectful, but it is truthful.
I'll let somebody else, I mean, I have an opinion, but I'm curious about everybody else's. Yes? Bob?
Hey, Mike, one of the things we teach is the wording.
Yeah.
We talk about smacking versus hitting. Okay, so the words matter. So the stronger the word you're trying to do in terms of describing the alienated parent, the better off you are. Okay, so, you know, mislead, if you feel anxious about defrauding, that you're misleading the court, it's certainly going to be I think you need to do it.
I think part of it too, if I can respond to that now, I think part of it is something we haven't addressed, and that is reading the judge. I mean, judges have so much discretion, and I always try to do a little bit of research on the particular judge. I mean, some judges really don't like expert testimony. Some just they can't tell me what to say or what to think. Some judges do. You should present those cases very, very differently. If they're presented the same, just because it's the evidence, and I got to show it, it won't work. It won't work. You have to be sensitive to your audience. Yes, sir.
Ryan Ludmer is going to answer your questions specifically about, in a hot topic area, about how do you talk to the judge. You may not want to use language like that to the judge because those are conclusory statements. And you can ask Brian Ludmer about that, and you can ask Kelly about that. You can ask Kathleen about that.
But again, I think it depends on the judge. I think there's some judges you would, some judges you wouldn't have. It's really kind of a judgment call. Generally, this is just sort of a general observation. I mean, there are really two ways to argue a case, and as I've witnessed. One is one channel, I call them channels, is a fact witness channel that describes the events of the case, the incidents that have happened. And then the other channel is the expert. We always think of the expert as, you know, I think of it as a sort of a separate channel. What I have found, one of the mistakes I see all the time is an inadequate development of the fact case. And if we just run an expert in, they'll make sense of it. It doesn't work that way. I think you have to establish a powerful fact-based case that's based on behavior. Without that, the best Richard Gardner could come back from the grave, and that would not sway anybody. I mean, I think that has to be really understood as being very, very important. Yeah, Bob.
And just quick, we're not necessarily telling the judge that this other person is misleading them, but you might be asking an expert, what would that mean to you if this person is doing this? So it's the expert that's labeling the behavior.
Right, I mean, so an attorney typically, although attorneys do testify, they're not really supposed to, right? But it happens all the time, and no, the other opposing attorney often does not object to that. Your Honor, the opposing counsel is testifying. It happens all the time in these cases, but it should be objected to, I believe you'd agree, but it often doesn't. But very often the judge is not, I mean, the attorney's not addressing, not supposed to be addressing, other than opening and closing statements, but it does happen. But I think that should be objected to, too, because it really is a violation of how it's supposed to work. Let's see, tier 1, tier 2, does that make sense? About how to arrange this, and how you really have to build that foundation. I cannot stress that enough. So that takes a lot of, guess what, preparation, and a lot of digging, and a lot of time. And if there's one error that I see family law attorneys commit all the time, is they're too busy. They have too many cases, and it's just difficult to do the necessary preparatory work to argue one of these cases. I mean, it really, these are high maintenance cases. They really are in terms of preparation. So if you can't just go in and sort of toss around an expert and expect these to be successful, it won't. In my experience, it's very unlikely to happen. And again, what's the purpose of this? We're going to weave you through this all throughout the whole thing. Okay? Well, we sort of talked about the lie list. I mean, I really, that crystallized for me from our conversation those years ago, Demas, and it's a regular thing that I create now, and try to get clients and attorneys to look for the specifics that will really meet the grade to do that. Because if you do that successfully, the other stuff really gets in there and is much more persuasive. In the case of attorney, I mentioned this earlier, if an attorney doesn't like expert testimony, I mean, is that everyone's experience? Some do, some don't. I mean, there's a wide range. And in terms of how would one present a case to a judge that doesn't really care, doesn't appear, has a reputation for really not liking experts, how would that be different? Anybody? Yes, Brian, I think you know the answer to this.
Yeah. Well, firstly, you have no choice. You have to present the expert evidence. You have to make the argument. Thanks. You have to make the argument in the course of the voir dire or mini hearing, qualifying the expert, that the reason why they're there, what they can offer, is that there's issues in the case that go beyond the usual knowledge base of a court, that the ultimate adjudication would benefit from having that sort of insight. So the very argument you're making to get them qualified in the first place makes the case for why they're necessary. If the judge gets that wrong, that's clearly an appealable fact. Almost any experienced judge knows that. They don't like to get appealed, properly framed. You should therefore be able to get an expert in.
In addition to that, one of the things that I used to train criminal defense lawyers who would, 95% of the prosecution's experts get admitted and 25% of the defense experts get admitted because of prosecutorial lock. You have a constitutional right to put on your story. This is your day in court. You have a right to put on your story, and if that includes your expert, they're going to get drop kicked by their Court of Appeals if they disallow a credible, qualifiable witness. Push it.
Yeah, no, I completely agree. It must be pushed. However, I have seen that happen and then they don't get drop kicked. But I think that's still the position you have to take. I mean, that's still the position you absolutely must take. Cross-examination, I mentioned the Dwayne Wade case. I mean, that's so important. I mean, that to me is the final punchline of these cases when they go to trial or hearings preceding that, is being able to have the alienating parent on the stand and to cross-examine them. And I think to generate evidence that you can use to be able to cross-examine them is critically important. So I think deposing them as many times as you can very often will help generate the material you need to cross-examine. One of the things that I've seen over and over again
is in an alienation case, you have the targeted parent sitting at this table, the alienating parent sitting over there. The cloud of suspicion, of course, is hovering over the targeted alienated parent, and this one's sitting over here quietly. And I have seen the alienating parents sort of not even show up for hearings. They really try to disappear from the purview of the court. They really do. They try to get smaller and really not, and have all the attention go over here. So I think that's a principle we need to be aware of, and another reason to shine the light back over here in whatever way we can. Even if it seems trivial, it is important to do that. Making your client, it will not make your client look bad if you do that. I think that's very important to emphasize, in spite of what I believe probably a great many family lawyers, how they're trained. It's, in my experience, that's completely inappropriate in these cases. Okay, and of course the purpose of this is to do what? Thank you. You're going to leave with that in your mind, aren't you?
Yes.
Okay, good. We all know this. The psychological makeup, and I'm sort of reaching the end here, so I've got a few more minutes, so please think of some things to ask me, okay, if you could. The psychological makeup of the alienating parent are typically these three familiar personality disorders, or some admixture thereof. The characteristic that they all share in common, as we all, I think, probably know pretty well, but I think it's interesting to follow this thought through, is that all of them, or none of them, have the ability to critique their own behavior, do they? They can't step outside of themselves and go, oh man, I should have said that better, I could have done that better. Like we all do, that normal response of self-critique that normal people have, as adults anyway, as you grow up and develop that. And if you think about what that means, if someone is operating under the burden of one of these personality disorders, and things aren't going the way that they think they should, because these people all are very controlling, aren't they? That's another characteristic we see with these, is they're very controlling within relationships. So if something isn't going the way that I think it should, and I'm operating and I have one of these personality disorders, guess what? It's always somebody else's fault, isn't it? And I believe it. And I believe it in my soul, and I will be very persuasive in it. And I will operate by, well, if it feels that way, it must be that way. And so that's one of the things we have to be able to expose, is that that's how these parents operate. That typically is done through expert testimony. That can be folded into the hypothetical testimony that I think I've seen be very effective in these cases. Yes?
I've heard some numbers thrown around, and I'm wondering if anybody knows, if there's been a study, what is the percentage of alienating parents that do suffer from personality disorders?